Hello everyone. Today we're going to talk about how to resolve business dispute in China. It's going to be an introduction to the Chinese arbitration and litigation system. This presentation is and it's organized by the EU SME Center, which is an EU Commission-funded project which helps EU SMEs prepare to do business in China by providing them with a range of information, advice, training, and support services. The center is implemented by a consortium of 6 partners, which are business chamber of European countries. It was established in October 2010. It completed successfully the first phase in July 2014, and it has now entered in its second phase, which will run until July 2018. I am part of the French Chamber of Commerce in China. My firm is part of it. The French Chamber of Commerce in China is the first network of private French companies doing business in China. It was created in 1992 with today more than 1,500 members. It has 3 branches, one in Beijing, one in Shanghai, and one in Guangzhou, and one office in Shenzhen. The French Chamber of Commerce in China organizes business events such as working group, conferences, networking events, gala nights, 2 per year, one in Shanghai and one in Beijing. It provides business services it has accompanied in 2016 more than 100 French SMEs. It has business center providing some services. It organizes training for especially in particular employees of French companies. It helps to recruit also. It's a recruitment center helping the French companies to hire a right profile in China. And it published a magazine called Connections, which include articles about the business and the legal environment in China. My name is David Boitou. I'm a partner at Gide Law Firm. Gide Law Firm is a French origin law firm. We have been doing business in China for the past 25 years. I was myself for 10 years the managing partner of the Shanghai office of the firm from 2000 until 2010. I went back to France for some years where I basically advised Chinese players for their investment in Europe and in Africa. And I'm now back in China where I'm supervising our offices in China. We have offices in Beijing, in Shanghai, and in Hong Kong. Totally, we have 40 persons in China. And we are one of the first foreign law firm to have established business in China. The agenda of the presentation today is about how to deal with dispute resolution. Maybe as an introduction, I want to mention that this is something that is now quite a hot topic in China. During my first stay in China from 2000 until 2010, we have very few litigation to deal with. This was not the main business, and very often litigation or dispute between French company or European companies and Chinese partner were settled through agreement, and very rarely we recourse to the arbitration or judicial system to resolve dispute resolution. This has changed definitely since I came back last year. We have to deal with much more litigation than before. It means that basically the Chinese partner or counterpart in a contract are using much more the judicial leverage than before. They don't hesitate now to go to dispute resolution, litigation, or arbitration. This is something that is new, definitely. So we have to pay a greater attention to this specific aspect of the relationship between foreign and Chinese partner into China. I will give you today an overview of the PRC judicial system. Then I will try to compare and to give you some recommendation on whether we should go to litigation or to arbitration before concluding. Regarding the PRC judicial system, this is something that is quite well organized now in China. The People's Court are the judicial organs. They have a general jurisdiction encompassing civil, commercial, criminal, and administrative cases. Now it's more than 3,500, 3,600 to be precise, tribunals, and 190,000 judges. This is the judicial court. You have then the People's Procuratorate, which are in charge of public prosecution in criminal cases only. And you have, this is something that you should know, some special people court for specific matters, specific areas. Military, which is not that relevant for business in China. Highway transport, this is more like civil cases, accident in relation to the railway transport. Maritime affairs is also very specific. Forest, and something that is quite relevant for you because you may face the litigation before the court is for IP matters, which are dealt with by specific courts with specific skills. Beside the official and judicial system, you can find in China around more than 180 arbitration and mediation institutions. I cannot list all of them. It would be obviously too long, but you have a lot of them. But for foreign-related arbitration proceeding, and we will discuss about that a bit later, the most famous one, the most known one by foreign investors doing business in China, and which are dealing with foreign-related arbitration, are the CIETAC, the China International Trade and Economic Arbitration Commission. This is the most famous one. The Shanghai International Arbitration Center, it's quite known and used also. In Shenzhen, you have the Shenzhen Court of International Arbitration, the China Maritime Arbitration Commission, which is a bit specific. Then in Shanghai, you have a second one, which is the Shanghai Arbitration Commission. And you have also the Beijing Arbitration Commission in Beijing. In both Shanghai and Arbitration Commission and Beijing Arbitration Commission, you have specific, sometimes department in charge of more banking or financial matters. This is basically the one that we are using in contract and for which we are comfortable to recourse in case of dispute between our client and a Chinese player. Going furthermore on the judicial system, you have several levels of court having a jurisdiction in civil, criminal, and administrative cases. The first level at the district level is the primary people's court. You have then the intermediate people's court, and then the higher People's Court at the provincial level, and then the Supreme Court, which is based in Beijing, and you will see quite useful. I will not go back to and talk about again the specific courts, which are the Forest Court, the Highway, Maritime, and IP courts, which are very specific. As far as the judicial personnel is concerned, this is something quite important to understand actually. Since 2002, judge and prosecutor are required to take the national judicial examination, the same examination as the one taken by a lawyer. This was actually a great step towards a more professional judicial system in China. Before 2002 and before some years, the time that all the people were taking the exam, one of the concerns we had in connection with the judicial system in China was the fact that the judges were not professional enough. They were appointed locally. They were quite sensitive to local pressure, and more of all, they were not that professional in terms of legal skills. The fact that they now have to take the national judicial examination, which is quite a complex one, it gives definitely more comfort on the fact that they're going to judge in law and according to the law, and that the tribunals, whether civil, commercial, or administrative, are more reliable than they were before. This is quite an important step to be noted. Just for you to know, as far as criminal cases are concerned, the People's Courts usually have their own judicial police force to assist them in their tasks. So this is something quite important for criminal cases. As far as the conduct of trials is concerned, the basic, the legal ground is the civil procedure law of the PRC, which was amended and re-promulgated in 2012. There is a practice in China. The judge will always favor the parties to reach a settlement by way of mediation. And it's quite significant because out of 10 million civil and commercial cases, approximately, more than 5 million have been solved through mediation at all levels of the People's Courts, the level we just described before. This is something that is quite specific to China. There is this definitely habit, which is a good one, to try to settle the cases instead of to go to the final judgment. This is something specific because this is something that is encouraged by the tribunal to avoid cases. The disputes are usually in public. There is some exception, but if we talk about business related disputes, this is usually what is part of the commercial dispute. This is usually held in public, and this is one of the drawbacks of litigation versus arbitration, obviously, because arbitration is confidential, whereas litigation, judicial litigation, is public. You can appeal to judgment by the immediately superior People's Courts. Judgments are final. One thing to be noted from a technical perspective is that appeals against judgment does not necessarily result in a new judgment. The court dealing with the appeal may ask the first instance People's Court to judge again, to withdraw, which is quite common and similar to some other jurisdiction in Europe. The Supreme Court has also a quite important role. We'll see that later for arbitration, for the enforcement of arbitration. But they can also decide to take over a case from a lower level if they consider that the text is relevant and worth taking over. One thing to be noted also, and this is something that is different from many other countries, is that most of the trials are relatively fast. It's around 6 months, which is, I can tell you, if you compare to France, this is very fast. So this is an advantage, definitely, of the judicial system versus arbitration. One of the advantages, but we'll go back to that later. So as far as the dispute resolution mechanisms are concerned, there is always this question between when we discuss with clients and when we advise clients about the dispute resolution mechanism to be included in the contract that they sign with the Chinese partner. There is always this question whether we should use litigation versus arbitration. The pros and cons of each of them are pretty clear. Litigation is definitely something low cost. The cost of litigation is very minimum. You have the possibility, if you recourse to the judicial system, to request from the tribunal some freezing orders to preserve some evidence. Or to preserve the assets of the company or the partner that you try to sue. This is fast. I talked about that already, but this is in China at least pretty fast. The cons of litigation in China are the first one, which is could be still an issue. It's what I call the outside influence. It can go until bribery sometimes. We have to be clear about that. I believe that it's very different from a place to another. But China is a big country. Judges are very often close to the local authorities, so they could be a kind of protectionism from or influence from the local authorities to preserve or to protect some player locally. So this is something that we have to take into account. It is said very often when you go to litigation that basically the decision of the judge is discussed before the actual trial. So there is some discussion which is quite unusual between the judge and the party or the lawyer of the parties. Is something that you have to take into account in if you decide to go or if you are attracted to judicial litigation. Obviously, another cons is the lack of specialization. So I will put aside the IP matters, which are, as I said before, under specific and more professional and specialized judges. So this is something that is working pretty well, at least as for trademark infringement issues. And you have a lot of another cons is they have a lot of level of competence depending on the cases. Depending on the amount of stake, is quite complex to understand. If you look at arbitration, obviously this is the cost is higher. On this particular aspect, I would say that the cost of Chinese institution, arbitration institution, for instance, the one we listed just before, the CIETAC, the Shanghai Arbitration Commission, the Beijing Arbitration Commission, all this arbitration is more expensive than litigation, obviously, but it's still less expensive than international arbitration, the one you may want to use in Hong Kong or in Europe, in Geneva or in Paris, the CCI or ICC. Sorry. So this is way less expensive than international arbitration institution, but it's still more expensive than litigation. Enforcement issue. This is definitely, you have less possibility to use. You need to basically go to court to get some enforcement decision. The arbitration tribunal has no jurisdiction to decide enforcement of the arbitration decision. This is not fast. This is quite a long process. But again, in China, more faster. I would say that what we can see outside of China within International Arbitration Center. This is the cons. The pro is definitely confidentiality. This is confidential. This is more predictable. Arbitration is less subject to alea or uncertainty than judicial system, even though this could be discussed. You can choose definitely both the place of arbitration, but also the quality, the skills and the qualification of the arbitrators. This means that you will try to get people that are more specialized to the case you have to deal with. Overall, the choice between litigation and arbitration is different to make. If I may say today, if I have a contract between a Chinese company and a foreign company, I would still recommend to use arbitration. This is definitely for me more reliable than anything else, and you don't want to take the risk of the judicial system on this kind of significant contract. Now, if I am a foreign player and I'm entering into a commercial contract, like a supply contract, distribution contract, it's quite a straightforward, simple contract. I think to have the judicial litigation as a dispute resolution clause is something that I may consider. Again, it will depend on the location maybe, but this is something that I can consider because this could be fast and could be good enough. So really it's on a case-by-case basis, but we shouldn't exclude in all cases judicial system in China. We could still recourse to the judicial system in certain occasions. How arbitration work, because this is still the most used and common dispute resolution mechanism in China for contract between foreign and Chinese companies. It is definitely something that I would say the majority of the dispute resolution mechanism in those contracts with I would say foreign related contract are arbitration. We can use different arbitration institution. We can use an arbitration institution outside of China. This is something that is possible. As long as there is what we call a foreign element in the contract, and thus it will be a foreign related dispute. It means that when one of the parties is a foreigner or a foreign enterprise, a foreign organization, and this includes a company incorporated in Hong Kong, Macau, and Taiwan. This is also the case when the habitual residence of one or both parties is outside of the PRC. It's also the case when the matter, the legal fact related to the establishment, modification, or termination of civil legal relationship between the parties which took place in foreign countries, or the subject matter is located in foreign countries. Basically, if we don't enter into details about that, if you have a contract between a company established outside of China and a Chinese company established into China, this is what we call a foreign-related dispute. And for this kind of dispute, you have the choice to use an arbitration institution outside of China. So it is typically the most common one is the International Chamber of Commerce, the ICC one, with the seat of arbitration that could be in Europe, could be also in Asia. You have also the Hong Kong Arbitration Center, which is quite known and used by parties in contracts. You have also one in Singapore, so you have really a lot of choices outside of China. You can also use arbitration institution in China, located inside of China. This is one of the arbitration institutions that we mentioned earlier. It's the CIETAC, the Shanghai Arbitration Commission. What else do we have? The Shanghai International Arbitration Center, the Beijing Arbitration Commission. This is the ones that we are usually recommending for dispute resolution for foreign-related dispute matters in China. Just one specific point to be mentioned is very often the European companies, when they start doing business in China, they establish entities in China, either in the form of a joint venture, which is a partnership between a Chinese company and a foreign company, or directly what we call the wholly foreign-owned enterprise, the WFE, which is 100% subsidiary established in China by foreign investors. So these companies are deemed as Chinese companies. So if this company enter into a contract with another Chinese company, let's give you an example. I have set up a WFE to sell some product. It's called, and then I enter into a distribution contract with a distributor in China. This will be deemed as a Chinese or domestic dispute. It is not a foreign-related dispute because it's between two Chinese entities, even though one of the entity is a foreign-invested entities. And then you cannot choose. You cannot choose arbitration outside of China. You have to choose arbitration inside of China, but you can use CIETAC and all the other that we mentioned earlier. Going back to foreign-related dispute, why choosing arbitration outside of China within ICC or Hong Kong Arbitration Center, to give you an example, instead of using CIETAC? We'll discuss about that later, but definitely the procedure of international arbitration center like ICC, Hong Kong Arbitration Center are still more flexible for the party to deal with. There is still more, they are more specialized. There is more freedom in terms of choosing the arbitrators. So this is, I would say that the arbitration center, the very famous one outside of China, are still more efficient for dispute resolution than the one into China. Even though it's the procedure now are becoming similar, this is the quality of the arbitrators are improving. There is still more constraints in terms of the proceeding for the arbitration institution inside of China, versus the arbitration institution outside of China. Litigation, we talked about that a bit earlier. I was basically saying to you that 5 to 8 years ago, I would never recommend to a client to use in a contract the judicial system as a dispute resolution mechanism. There were too many uncertainties on the outcome. We were not that confident on the quality of the judges. This has changed, I believe. And when you look at the World Bank doing business report that we have produced in the presentation, this is quite interesting to see that basically the quality of the judicial processes in China is not that good, but it's not that bad. So it means in terms of timing, in terms of cost, and in terms, obviously, on something very important, which is the quality of the judicial processes. So here the example is for Shanghai. And again, we have to take into account that China is a big country, so we cannot necessarily rely similarly on something that will happen in Shanghai or in Beijing versus a country or versus cities which would be more remote, even though it is improving everywhere in China. So litigation is something that I could consider to recommend for certain simple contract for which there is no confidential issues, and for which we could go to litigation because it's faster and lower in terms of cost. So something that to consider, with some, while being cautious, obviously, but something to consider for certain contract on a case-by-case basis. Enforcement of arbitral award. This is something that you will see with this slide. The weakness, I would say, of the arbitration institution outside of China. So if we look at foreign-related disputes, disputes involving a foreign element, for instance, a foreign party in a contract. China is part of the New York Convention, so there is a legitimate right of enforcement of the arbitration decision rendered outside of China by a foreign arbitration institution, which has a limited number of grounds for refusal, which are all procedural grounds in terms of protecting the proceeding of the arbitration, plus one ground which is the ground that may raise some difficulties, which is the violation of the public policy, which is a concept quite vague, and basically you can consider that many things can be included in that concept, and this presents obviously some risk and some room for the local court to refuse the arbitration. There is basically something that could be considered also is the delay by the local courts in terms of enforcement, and this is an issue because when you got an arbitration decision in your favor and you need to enforce that against a Chinese company, time is the essence. It means that you need to enforce that quickly to avoid the risk that the Chinese company try to escape the enforcement by transferring his assets. And this is something that is not theoretical. It's something that I have seen in some cases. So this is something that you have to take into account. The refusal to enforce international awards, so awards given by International Arbitration Center, are not that common. This is something that we cannot see very often. Obviously, the delay is an issue, but the refusal to enforce in arbitration cases is very rare, and this is something that is not that an issue in my opinion. You have to know that in any case, local court cannot refuse to enforce the international award without first reporting and obtaining the prior approval of Supreme People's Court. So there is some safeguard, I would say, in those procedures that allow international awards to be enforced in China. Delay is an issue. One specific thing to mention is definitely the Hong Kong Arbitration Awards, which is under a different system than the New York Convention. It means that in addition to what is common with the ground for refusal under the New York Convention, you have a specific arrangement between mainland China and Hong Kong. So you have the same ground for refusal of enforcement as under the New York Convention, plus you have a refusal ground which is the award is contrary to the social public interest. This is something that is actually broader than the public policy, and this entails more risk than the ground under the New York Convention. So Hong Kong awards could be subject to more refusal of enforcement, and we have the same issue than for other international awards, which is the delay. So this is the reason why sometimes we would recommend, especially if the Chinese counterpart or the Chinese partner of our client does not have any assets outside of China, assets that could be used to secure the enforcement of international awards without having to get this award enforced by local court in China. So if a Chinese partner, most of the Chinese of the assets of the Chinese partner are located in China, and when you consider the timing of enforcement will be definitely something very important in the cases, you may definitely recommend to use Chinese arbitration institutions that are qualified to resolve foreign-related disputes. This is typically CIETAC or the Shanghai International Arbitration Center, the Shenzhen one, the Shanghai Arbitration Commission, and the Beijing Arbitration Commission. Definitely, this is a plus because this could be enforced more efficiently and more quickly, which is key, than international awards, because there is only ground for annulment or refusal on the basis of procedural grounds. And only if he violates the social public interest, which is not that relevant, and they have to obtain also the approval of the Supreme People's Court. I have not experienced in the past years case where domestic awards, so awards rendered by Chinese arbitration institution were refused to be enforced by local court. This is something that is quite important and could be one of the key aspects to take into account when deciding whether you go outside of China or inside of China. Again, I want to mention that Chinese arbitration system is not at the level in terms of specialization, in terms of flexibility, in terms of efficiency, at the level of the international arbitration institution. Definitely, we cannot say that today. This is improving. This is something that we have to, but even though it's not still at the level of this international arbitration institution, we have some means to improve that by drafting the right dispute resolution clauses and to insert some key elements that will allow to circumvent the drawback of certain local arbitration institutions in China. One word on domestic institution. You definitely also you can use for a domestic dispute, i.e. contract between your subsidiary in China and a Chinese company, or between your JV in China and a Chinese company. You can definitely use also domestic arbitration. This is something that can be seen. Again, this is something for significant contract where the amount at stake is important, where confidentiality is key. So this is all these reasons that may lead you to recourse to domestic arbitration. So the way, maybe to go on this particular aspect, the way to improve the functioning and the flexibility of the Chinese arbitration institution, the one that are used quite often now, such as CETAC, we have to be careful about how to draft the dispute resolution clause in contract. The CETAC, if we take a CETAC, but it's something that these kind of clauses are very similar to all the arbitration institutions. So we took here the example of the CETAC, but it's very similar for the other institutions. So the typical clause is the one that you can read. The model clause is any dispute arising from or in connection with this contract shall be submitted to China International Economic and Trade Arbitration Commission for arbitration, which shall be conducted in accordance with the Commission's arbitration rules in effect at the time of applying for arbitration. The arbitral award is final and binding upon the both parties. Very standard clauses. What you can adapt and what you can do to improve a bit the mechanism is several things. First one is definitely the location. You can choose the location between Beijing, Shanghai, Shenzhen, whatever. You can also choose the language. You can decide to impose English language for the proceedings. It's something that is possible to do. This is, I agree, difficult sometimes to negotiate with a Chinese partner, but you can definitely impose English versus Chinese, even though it's not very common. Most importantly, the composition, the formation of the arbitral tribunal. First, the number of arbitrators. You can have a proceeding with one arbitrator versus a proceeding with 3 arbitrators. One arbitrator is usually for relatively simple cases where you don't want the cost to be too high, when the subject matter is not that complex, could be quite straightforward. And for these kind of things, you can definitely have one arbitrator instead of 3 arbitrators. Then you have the mechanism with 3 arbitrators, where each party choose one arbitrator. And for this particular aspect, most of the arbitration commission in China now, they allow to choose arbitrator outside the list of arbitrators. It's not the case for all of them. This is something that is very common for arbitration institutions outside of China. In China, you you had to in the past choose within the list of arbitrators, but the list has been quite extended, so you have the choice between foreign arbitrators, Chinese arbitrators, and more specialized arbitrators. So this is improving, even though it's not as flexible as the institution outside of China. This is definitely improving, and so you may choose that. And then each party choose one arbitrator, and then usually in arbitration outside of China, then the two arbitrators may choose the presiding arbitrators. So you still have some flexibility and some leverage to choose the right one. If you look at CIETAC, this is something very specific to CIETAC, and sometimes the foreign client, they are not that happy about that, is that the presiding arbitrator is chosen by the CIETAC president. So it's not chosen by the arbitrators appointed by the parties, it's chosen by the president. So in order to avoid issues and to be sure that the presiding arbitrator is fair, you have to add in the dispute resolution clauses the fact that, for instance, the presiding arbitrator is not of the nationality of either party. Is not Chinese or, for instance, or French if the dispute is between a French company and a Chinese company. So you may have some leverage here that you have to take into account. You have basically you can choose also the decision-making process, so there is some flexibility in that, and definitely you can adapt you can choose the arbitration commission depending on the expertise of specific commission that have arbitrators that are more specialized on certain business. So this is something. These are example of what you have to take into account when you draft a clause. You have to adapt a bit, and you are free to do it to a certain extent. You have to adapt a bit to try to reproduce, I would say, to guarantee, to secure, to ensure that the arbitration proceeding in China will be very fair. You have to anticipate that by drafting properly the clause in the contract and try to circumvent, I would say, the drawback on certain proceeding applicable in China. This is the same for arbitration outside of China. Definitely, you will definitely adapt and try to choose the right clauses, which is very adapted to the subject matter, the area of the that we are dealing with. So this is something that is very similar between international and domestic arbitration. Obviously, the goal is the award to be final and binding. You will still have some constraint in terms of enforcement that we described before. And then you may ask, it's not that easy to do that for Chinese institutional arbitration, but you need to definitely try to request consolidation on joinder arbitration proceedings, because you may have several arbitration dealing with related subject, and it's something that is quite common in outside of China, and this is something that you have to take into account and to anticipate for Chinese arbitration clauses or model. Conclusion after this introduction, because this is a quite complex subject. We can talk about it for hours, and I'm sure that many people have various experience dealing with litigation system in China versus arbitration system. Again, for significant contracts, like important distribution contract, franchise contract, for instance, joint venture contract, manufacturing contract with some exclusivity, I believe that arbitration is still a must. I would not recommend the judicial system as a dispute resolution mechanism at this stage. So arbitration is a must. Then deciding or choosing between arbitration outside of China, inside China, I would say that when the assets of the Chinese partner are located in China, Chinese arbitration institution will be still the preferred solution, even though the proceedings are not as flexible and as efficient than the one of the international arbitration mechanism or institutions. Judicial system, why not? Again, for straightforward contract with no confidential issues, and in certain cities in China, you may definitely recourse to the judicial system in China. You have the possibility to ask questions by registering and logging within the website of the EU SME Center, www.eusmecenter.org.cn. You can ask questions, and we will be happy to answer your question. Bye bye now. We are done with the presentation, and hopefully we will have the opportunity to talk very soon. Bye bye.